Good morning. I am really sorry that I can't be with you today, but my doctor put me on a no-fly list and told me to phone it in. So here's my phone call. I want to talk about federalism and takings. Oxymoronic combination of words, in my humble opinion. Don't get me wrong, some of my best friends are Federalists, probably some in the room now. It just brings me up short when someone proposes to apply the concept of federalism, which I'm using in this context to denote deference to state control, to issues of fundamental right without first establishing and acknowledging the existence of a uniform federal baseline of constitutional protection. Because here's my core belief about our Constitution. A central point of our Constitution in general, and its Bill of Rights in particular, is to provide a baseline of protection to all the rights of all citizens, with individual states having the discretion to provide more, but never less protection. So let's get to the bottom line of this discussion at the outset. If there is a role for federalism, it lies in providing a mechanism for the states to provide more protection to individuals than the U.S. Constitution mandates. Period. Professor Akhil Amar summarized it simply, and I think eloquently. Quote, "The federal Constitution stands as a secure political safety net, a floor below which state law may not fall." End quote. Citations, by the way, for anything that I discuss are in the paper that's part of the background materials for this program. Maybe it's because I've practiced constitutional property law for half a century in California that my blood runs particularly cold at the thought that individual states are free to establish their own rules. Maybe it's that 50-year experience of getting beat up by judges on the left coast that leads to my being cautious. Check my paper if you don't believe me for references to numerous commentators on all points of the political spectrum who will bear me out. Remember, this is the state that was told directly in First English that it was not properly following the Fifth Amendment. And then, a scant 2 weeks later, was told in Nolan that no other state in the country had exaction rules, which the court likened to extortion, as severe as California. Professor Sterk has acknowledged that some of the states, and he must have had California in mind, have had what he called a, quote, checkered history of defending the rights of property owners. Checkered indeed. Check my paper, you'll get a clue as to what kind of protection property owners get in California. He also noted that some states, notably including California, immediately after First English was decided, began undoing the protections provided by the U.S. Supreme Court. To the extent that we yield control to states like California, and who is to say that others will not follow its lead, I fear for the Republic. As the Wall Street Journal noted recently, quote, "California is often where bad ideas spring to life these days, and they're worth highlighting lest they catch on in saner precincts," end of quote. This being a room full of property lawyers, you'll be interested to know that this comment came in the land use context. The article related to a new requirement in California that all new homes be equipped with solar heating panels at a time when housing is already priced out of the reach of ordinary citizens. Sure, let's pile something else on. So let's talk about the views of the founders for a moment, because that's where the federalism idea came from. Remember these things about the founders. First, they had just endured life under the Articles of Confederation, a monstrously weak form of government that had a weak center and strong powers on the periphery. While they wanted to retain some state control, they knew that too much of a good thing was too much indeed. Second, they were concerned about protecting the rights of citizens in general and property owners in particular. Remember, the founders were in general owners of property. More to the point, they knew that the Articles of Confederation had done a poor job of protecting individuals. As Professor David Shapiro, one of the country's foremost authorities on federal jurisdiction, put it, It is hard to quarrel with the conclusion that the historical record, viewed in its entirety, fails to support the existence of state autonomy as a critical means of protecting against abuse of governmental power. On the contrary, national power has had to be continually invoked in order to protect our freedom against state infringement. Thus, notwithstanding, as the Supreme Court put it, that every school child learns that our Constitution establishes a system of dual sovereignty between the states and the federal government, those same school children also learn that the federal law is paramount when the two systems diverge. That's because the Constitution contains a provision popularly known as the Supremacy Clause, embedded in its heart. This provision declares forcefully, quote, "This Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of the state to the contrary notwithstanding." Let me give you that last one again, just for some slight emphasis in this context. Anything in the contrary, anything in the Constitution or laws of any state to the contrary notwithstanding. Now, I'm quoting this not because I think you never heard about it, but because it is critical to keep in mind when discussing the relationship between the states and the central government. And that brings us to a second set of what we might call founders in the mid-1860s. As some have put it, they settled, no later than Appomattox, the idea that individual states had the right to make up their own rules. They don't. It took a while, but the post-war constitutional amendments and the statutes Congress enacted in their wake, chief among them 42 U.S.C. Section 1983, changed the structure of the country. To the extent that federalism carried sway after our revolution against England, it was essentially replaced by Section 1983 as the engine of enforcement of individual rights in the last century and a half. During that time, most of the provisions of the Bill of Rights have been incorporated into the 14th Amendment's due process guarantee. And as the Supreme Court has repeatedly said, this court decades ago abandoned the notion that the 14th Amendment applies to the states only a watered-down subjective version of the Bill of Rights. They are enforced against the states the same way the originals are enforced against the federal authorities. We are at another possibly revolutionary moment in time. The worst aspects of federalism are reflected in the Williamson County opinion, though, to its credit, it never uses the word federalism. Where the general run of Section 1983 cases contains thoughts about throwing open the courthouse doors and establishing the federal courts as shields between the citizens and government agencies, Williamson County slammed the federal courthouse doors shut, keeping citizens on the outside. The post-Civil War legislation of which this statute was a part dramatically altered the relations between the states and the federal government by giving the federal courts authority they did not previously possess. Williamson County is wholly out of step with the mainstream of Section 1983 law. The organizers of this conference, giving them credit, had the foresight to schedule it during the week in which the Supreme Court decided to reconsider Williamson County and its requirement that regulatory taking plaintiffs must first sue in state court and lose before being able to sue in federal court. At that point, however, those of you who remember law school will recall that the full faith and credit clause kicks in and precludes federal litigation. But you all know that, or you wouldn't be here. Let's just say that the argument on Wednesday in Nick versus Township of Scott was interesting, and leave it at that for now. I expect that others will not be able to resist discussing it with you. I will say this. Once again, several of the justices demonstrated either an inability to understand or a complete lack of interest in our subject. The paper I prepared for this conference for you tells you all you will ever want or need to know about Williamson County. hold your collective breath. It could be a bumpy ride before Nick is decided. I can't close without noting that there are some apologists for local government who believe that the court pays too little attention to the fiscal impact of liability rules on the government. Were it otherwise, they assert, the court might reach different conclusions. For my part, I am pleased to see the court adopting some rationality to its decisions. On this fiscal impact point, we need go no further than the decision a few years ago in Arkansas Game and Fish Commission versus United States, a unanimous opinion drafted by Justice Ginsburg, who may be the notorious RBG, but has never been accused of being a wild-eyed conservative, in which she labeled the government's arguments, that is, that it could not do its job if saddled with the true cost of its program, as a, quote, sky is falling argument that the court had grown tired of hearing and would appreciate it if the government would just knock it off. So, in the hopes that some of them might listen, I reiterate that for you. Knock it off. It's not an argument that sells. So, coming full circle to our subject, what's federalism got to do with regulatory takings? Damn little. The invocation of federalism carries no more merit in this field of law than it did after Brown versus Board of Education, when some southern states tried to invoke what they called the interposition doctrine, placing states as a barrier to the 14th Amendment, seeking thereby to evade the constitutional doctrine of equal protection in racial desegregation cases. Don't be fooled by this new disguise. Federalism has no place in regulatory taking cases other than to allow states to provide property owners with more protection than the federal government, the federal Constitution require, not less. Well, having said that, I would ask you to have a great conference. Thanks for listening. I wish I could be there with you. Farewell.